First two matters on the calendar, starting with appeal number 127, People versus Stephen Henderson.
Good afternoon. I'd like to reserve 3 minutes for rebuttal, please. May I reserve 3 minutes for rebuttal, please?
About 3 minutes.
Layla Hull from Appellate Advocates representing Appellate Stephen Henderson. Had counsel challenged one dispositive adjournment, it should have resulted in dismissal in this case. And that is a clear-cut error. Counsel needed to say that the people hadn't proven due diligence with respect to obtaining DNA testing of all relevant evidence in this case. This was an obvious omission because the people's obligation to establish due diligence, even when they're seeking an exception for extraordinary circumstances, is well established under this court's case law. Counsel should have made the argument because the people never, at multiple adjournments, and in their response papers, never even tried to demonstrate that they acted with due diligence in making a request for testing of all relevant evidence.
This is a direct appeal, right, counsel?
Yes.
Why isn't this a 440 motion? I mean, why do we have a record where we're going to go back in and reconstruct these arguments and the response, arguments that were never made, and rule that it's a 30-30 violation?
Because all counsel had to do was to hold the people to their burden. You don't need any further information. The people have to establish, in the first instance, affirmatively, that they acted with due diligence, and they never demonstrated that at all here.
But counsel, is it your argument that the people must submit for testing every bit of forensic evidence to be developed in the case at the same time, up front?
In a case like this one, where there are multiple perpetrators, so the scope of what counts as necessary testing is broader than maybe when there was one suspect, where the semen samples, for example, would have been dispositive. That's a different type of case than when you have here, where you've got multiple suspected perpetrators, up to, I believe, 6, or possibly more, and you have a complainant whose narrative has changed within the first few days of the incident. In that case, in this case, the scope of what's necessary to be tested is broader, and that was obvious here. And what is clear is that the people wanted a second bite at the apple.
But how do we know that the motion would have been dispositive? And don't we have to know that in order to fall under the one error rule? For example, might there not be a question about, I can think of several, but about whether the lack of the DNA affected the people's readiness, or whether they could have in fact gone forward, whether there was enough evidence in the record or enough evidence to go forward and establish a prima facie case without it?
Well, I think we have to, you can in this case, because if you look at the adjournments, the reason why the people were not ready on August 13th, just make sure the dates are right, was because the OCME's report wasn't final. That's their stated reason for not being able to proceed at that point. So, yes, we can in this case.
But that doesn't get to the heart of the question, I think, that Judge Stein raised, which is that this may be a substantive error. Is it a dispositive error? Will it change the outcome?
Yes, because again, the people have to establish due diligence. It's their burden. And when they don't, this is an element to being able to obtain the exclusion. And when they don't at all, either in their appearances on the record, and again, this court's case law has been very clear, the people have the burden of establishing at the adjournments or in their response papers conclusively that they're entitled to the adjournment, to an exclusion. And when they do not make that necessary record, they are charged the time. This court has said that in Stirrup, it has said it in Cortez, and if I'm mispronouncing the names, I'm sorry, and I believe also in Washington, where that's a case, again, about an investigation and people needing to demonstrate credible and vigorous efforts to move their investigation along. This is analogous to that. And here, the people never made any attempt. What they tried to do was to take DNA and use it as a blank check to get an exclusion under an exceptional circumstance. And even if you have DNA, it's not a blank check. You have to show that you made the request for all necessary testing, and it was the people's burden to do that. And the people are the only people, the only party to have this information.
Let's take it a step further. The serial testing, is that an event that is even in control of the people? Are you alleging that it is? Because OCME doesn't appear to, in my mind, to be in control of the people.
The people are in control of what what they're requesting to be tested.
Well, yes, that's a factual issue, right? And doesn't OCME control the sequence of the testing that would then take place?
Well, the people would again need to demonstrate that. And here, what we do know is that they haven't done so. And a reasonable reading of the record, the only reasonable reading of the record, is that the people thought that once the semen samples were tested, that's it. Because they adjourned ready for a final conference. They were ready to proceed.
Was that not a responsible approach on the part of the people to test the semen sample first? And if that came out the way I'm sure they were hoping it were to come out, not to move to the next extraordinary expensive step of conducting additional forensic testing?
Not in a case like this where there were multiple perpetrators. It's foreseeable from the outset that the semen samples may not physically tie all of the suspects to this incident. So not in this case. I agree with you. If this was a case where there was a single perpetrator and the semen test would be dispositive, yes. And then they could seek additional testing just to strengthen their own case in some way. But they shouldn't seek an exclusion for that. But not in this type of a case where you've got, the people should have known from the outset that the scope of necessary testing is broader. Their failure to establish that they made the request so that OCME would kind of consider all of the physical evidence, which would have been gathered in the same, in the same rape kit. This is all available to OCME at the same time, and that there isn't this round, this like preliminary result versus the final result.
Is that the rule that you would suggest that we adopt, that there has to be a request that would show due diligence, or are you looking for something more like some sort of document or documented evidence that a request was made?
At a bare minimum, they need to establish when the request was made. And because it shows to the extent the timeline, whether they're asking for, if they're asking for it in a reasonable time period. And it's the people's burden to do so, and they have not met it here. And the record indicates that they didn't make that request before knowing the results of the semen test.
Can I go back to your answer to the Chief Judge related to the serial testing? So are you taking the position then that there might be cases, I know you're taking the position this is not the case, but there might be cases where it would be an appropriate choice for the DA's office to do DNA testing in stages. The first stage proves negative, doesn't give them the results they wanted, so they go and test something else.
I would caution that there is a category of cases where that would be appropriate, but the one example that I can think of is when they know from the outset the semen test is going to be a dispositive one, that they can't, and so that would be the one place where I would agree that that might be a circumstance where you can test.
Is that where the defendant agrees but says it's consensual sex? When is that case, other than the example I just gave?
I think it's a question of the number, when you're not looking at ID. And that's what this case is about. This is about physically tying our suspect, to our client, to this case. So when ID's not at issue, then I don't...
You're saying when there's more than one perpetrator involved in the sexual assault or the rape, that's when you will always have to test all DNA, all samples?
All relevant evidence, where there's a likelihood that the semen samples, a specific category, isn't going to cover everyone. And the people knew this from the outset, because at the January appearance, they're talking about this may link one or two others. There is up to 6 possible perpetrators in this case. So they knew from the beginning that this couldn't cover everyone, and that by definition that means it could not necessarily cover this appellant. I'm sorry.
I'm still having trouble with the posture of this case and why it isn't Brunner, because it's an ineffective assistance motion, and you're asking us to rule on serial DNA testing, an issue that was never raised below, right? And in order for it to be ineffective, it has to be a dispositive motion that would have been made. And here we're arguing this novel issue in front of this bench. So how does that fit? I don't understand. Isn't this really a 440 motion?
No, because even though we're talking about DNA, the people's obligation to not string out the process of investigating their case has been well established by this court's case law. This court would never question charging the people when they tested, for example, for fingerprints, testing one finger at a time.
Would it not be helpful to know whether the OCME had certain protocols for the acceptance of submission of DNA testing evidence, if there's a prioritization assigned?
Regardless of that, the people should still have to establish that they made credible and vigorous efforts, that's this court's language, to obtain, in dealing with OCME's own priorities, that they sought testing of all of the necessary
And maybe
evidence.
they would have if the council had made the motion below.
They had multiple opportunities to make this. They were asked
But this
from-
argument wasn't specifically raised. That's why we're here on an ineffective claim, right?
Absolutely, but it's the people's burden to establish the record. All counsel had to do was say the people haven't met their burden. Based on that, there should have been a dismissal. So in light of the fact that that's a single argument that counsel needed to make, that's why this case is the antithesis
So
to
your argument
Bruner.
would be, once you do that, any argument with respect to why they didn't make the record is okay. We can consider that.
Well, they had a chance to, the point of a burden-shifting framework is to give the people their opportunity, and they had it. They had it multiple
But that's a
times
different
here.
issue than it's not preserved, right? So we've said this isn't preserved. There's no argument it's not preserved here. So, but that doesn't mean that the people didn't have the burden to come forward and make your record for you on an argument that wasn't presented?
No, because the argument would have been presented only in the reply. That's the only moment where counsel would have been able to say, because they would have seen what the basis of the exclusion was. And that's, at that point, counsel says, you know what, you didn't meet your burden. That's the moment when that argument
Maybe there would have been a
presented.
hearing, or maybe there would have been further inquiry by the judge, or maybe there, in a colloquy, or maybe we would have a further developed record, which really would be the subject of a 440 motion.
I know I'm past. Can I just make one, and I'll be done? If you look, the point here is if you look at the June 24th adjournment, the people, once they know the results of the semen testing, they agree to adjourn for a final conference. There is no outstanding request. They're not suggesting that there's going to be ongoing testing. This is the moment where they believe everything is final. It's after that that this changes. That's why this is unreasonable, and thank you for your patience.
Counsel?
Good afternoon. My name is Ann Bordley, and I represent the respondent. Defendant's claim of ineffective assistance of counsel is meritless on this record. Trial counsel reasonably chose not to challenge the excludability of the 50 days from June 24th to August 13th for 3 reasons, only one of which involves the exceptional circumstances in the due diligence provision of 3034G. The first reason is a very simple and straightforward 3030 exclusion. In the people's answer, the people said that on June 24th, defense counsel made a request for some additional paperwork. And then on August 13th, 2009, the record shows the people provided additional discovery. So that's a discovery exclusion under 3034A. So this exceptional circumstances, DNA testing, none of that even matters. And it's something the defense attorney would have known about. And so the defense attorney may not have chosen to contest this because he knew that the people were right, in fact, that this was a regular discovery delay. And for that reason alone, this claim is meritless. There's a second reason. The second reason is that there is, the part of this delay for this period was the production of the DNA report with respect to the semen samples. Now, the record shows that there were 3 different DNA reports that were produced during the course of the pretrial proceedings. But this refers to the first one about the semen testing. And this is the one that the defense attorney particularly wanted because the results did not connect his client to the crime. And so at one point on August 13th, the court specifically asked defense counsel, well, you know the results. You know it doesn't link to your client. Do you still want the report? And defense attorney said yes. He did want to see that report. And those documents are excludable under 3034A, again, as a discovery request. He's entitled to it as a matter of discovery. He's entitled to the raw data that the medical examiner's office developed. And in addition, in this particular case, he wanted to see the final report. He wanted to see the medical examiner's office its final report. And in fact, during the defense case, the defense attorney, they introduced it in the form of a stipulation, but he did introduce evidence of the DNA results of the DNA testing in this case. I know the defense attorney in their brief, they argue that, well, it took too long for the medical examiner's office to produce its report, but the appellate division has held that delays by third parties generally are not counted against the people for purposes of 3034A. And in evaluating the effective assistance of counsel, this court has emphasized that you do look at what the appellate division case law is. The court considered that in Brunner and in Baker and in
You get the impression sometimes that whatever the DA delay is, it's understandable, but if the defense does it, it's not. I don't understand why, if the medical examiner's got problems, why that inures to the benefit of the DA. You're supposed to be ready for trial when you indict the darn thing, and you ought to be going. We're talking about a case in 2009 that's now up here 7 years later, and we're arguing over days that occurred a long time ago. And it just seems to me that an exceptional circumstance would be something other than a delay by a medical examiner or someone else. That's kind of routine, and I would think at some point you would either move to compel the medical examiner to decide it, to get you the stuff, or try the case without it. But for the defendant, particularly if they're in custody and there's a presumption of innocence, to sit there because everybody just says, well, you know, he's going to take his time or she's going to take her time, and all of this time goes, and all of a sudden, you know, here we are arguing a case that's 7 years old, and I'm wondering where the speedy trial comes.
Well, for sure, and I would like to defend the medical examiner's office. They've worked very diligently and tried to speed up the amount of time taken by DNA testing. DNA testing has expanded.
So that would not be exceptional circumstances. It's just the way things go. And I would think that you would have that pre-indictment, wouldn't you?
It takes a very long time to do this kind of testing. I would note in this particular case...
Did you understand my question? Wouldn't you have that pre-indictment?
No, you don't always have it pre-indictment.
Not always, but why would, I mean, do you understand my point? It just gets troubling that, you know, and here the judge did a, you know, pretty extensive job of saying these 83 days, these 21, it's like a matrimonial. That's not what we're supposed to be doing. We say it's 6 months, this case is thrown out of court because it's not ready. Now, if there's a reason why it's not ready, it ought to be exceptional. And I'm not sure that delay in a normal course of a medical examiner or anyone else is exceptional.
If the defense attorney had raised this claim pre-trial, or if they were raising this claim now in a 440 motion, we would have the medical examiner's office come in. They would testify, and they would explain all of their efforts to speed up.
Didn't you need to explain that? You're
Well,
the
not
one
in
who's
this
saying it's excludable. Why aren't the people, why isn't that the people's burden?
Well, no,
To
well, Your Honor,
explain that.
this period was, the particular period at issue was excludable, partly for discovery reasons,
I understand.
partially for the
but
DNA
let's
report.
just stick with the DNA.
But with respect to the DNA, remember, there's the DNA report on the semen samples, and then there's also the testing of the fingernail scrapings. They represent two different issues. Because if you look at this, they had the DNA profile on the semen samples by the time of the arraignment on the indictment. I think that's in fact very, very quick, that by the time, but then they had to get the buccal swab from the defendants, and then they had to develop the DNA profile from that and do the comparison and do the report.
As I understand the argument, it's not the first round, the semen round of DNA testing. It's a sequential testing that's being attacked here.
Well, actually, for the three different reasons, again, you have this discovery that's unrelated to DNA. You have the DNA report on the semen samples, and that's related to the semen samples. It's only when you get to this third argument, our third fallback argument, where we say, yes, you should exclude for exceptional circumstances the time for the fingernail scrapings. Now, the record shows that we promptly requested DNA testing. We know we've got them already doing a DNA profile by the time of defendant's arraignment on the indictment. Now,
So look, it comes out, why'd you wait so long on the fingernails?
to that,
Why did you wait so long on the fingernail scrapings?
I'm stuck here because of the record, because if they raised it in a 440 motion, we would show, of course, the DA's office always wants prompt DNA testing, especially in a case like this. We had 7 perpetrators. We had only 2 under arrest.
But isn't that the point? So why don't you get to that? Isn't that the point? You're saying that's your burden to come forward with that to begin with. So why isn't it your burden? Because that's obviously your position. Why isn't it?
If the defense had come in, we would have responded about what happens when we give over a rape kit to the medical
You're
examiner's
saying under
office.
the statute, it is not your burden to put that information forward.
I think
it
that
is only your burden if they raise it.
I think if the defense...
Do you agree that if they had raised it, you would have had to come forward with that information?
Yes, I think it would have
So
been...
you agree then that your initial response was insufficient under
No.
the statute?
No, I don't agree with our initial responses. I think this court has held in Lupron and in Beasley and in countless cases about how this preservation works in this contest. Defense attorney only has to make a very simple, one-page request for it. We come back with a response. Then the defense comes in with their specific objections, and we start focusing on the particular periods. Had the defense attorney said this at that time, we would have come in, and we would have said, basically, we were not responsible for the delay. We asked for the rape kit to be tested. The medical examiner's office does what it does under its scientific protocols.
Counsel, are we collapsing these two arguments? As I understand it, the defense is arguing primarily that his counsel was ineffective because he didn't make an argument that that the people had not met their burden. And you seem to be talking now about the burden, but not in connection with ineffective assistance of counsel. You were talking about it generally. So
I was trying to respond to the question asked, yes. And the particular issue here is whether defense counsel was ineffective, and we can't evaluate that on direct appeal, at least with respect to the DNA testing, because you have not heard what we would have to say on this subject. And if defense attorney files a 440 motion, we will then present evidence from the medical examiner's office where you will hear them give facts and statistics about the huge number of DNA tests they are called upon to do, about their very, very diligent efforts to speed up that process. But on some occasions, in some cases, that's going to take longer.
I want to go back just a minute because you talked about other discovery and a period of time in which you say that defense counsel had requested further discovery. I was unable to see where on the record that request was made.
The prosecutor, in their answer, said that there was this additional request. And then on the August 13th, on the record on August 13th, there is just a general reference of an open file discovery being provided. And that's all that it says. But that would be okay, especially, well, this court in Berkowitz said that you decide the 3030 motion at the time, the 3030 motion at the time the 3030 motion is made. You don't have to decide it on each and every adjourned date, litigate 3030. But in particular, the Second Department has also held in a case called People versus Robinson, which is cited in my brief, said you don't actually, the fact that the prosecutor didn't mention the reason for the adjournment on the adjournment date doesn't matter if the record otherwise supports the prosecutor's explanation.
But I thought the prosecutor said we have more discovery for the defendant, not necessarily in response to any particular request, meaning that that an adjournment was due to that request. That's what I don't see any support for.
But the prosecutor did allege it as part of their answer. And here's a sworn allegation of fact by a prosecutor, which the defense attorney has not disputed, and it's something in defense attorney's knowledge, so he could have disputed that if he said, no, I didn't make that request, or you should have given me that stuff earlier. I was just making the request because you hadn't turned it over. All that could have been raised. But significantly, in this case, defense attorney never did challenge it. And the presumption has to be it's because he had a reason not to challenge it. And if the defense disagrees, they can bring a 440 motion, and then we can have the defense attorney testify about his reasons for not challenging this period, and the people can put in more evidence about what steps they took about the DNA testing and how the medical examiner's office in New York City handles DNA tests, because you can't make that decision about what was reasonable and what is a reasonable delay.
I understand. I guess it's my question is more the plaintiff one, in the sense that if they're so busy, what do you do? I mean, there's a 6-month statute of limitations here, or a speedy trial statute. And my thought is, what's exceptional about the fact that you say happens all the time? And so you, defendant, even though you've got 6 months, you really have a year and a half, because the OCME is so far behind, and we haven't gotten the tests ordered yet. So the 6 months is meaningless. I know that's not what you mean, but I'm just asking myself, you know, why is it exceptional if you say that's the way it is? It's not exceptional then.
Well, first I would break down some of this time. Some of this time that we're saying DNA is, part of this time is the motion practice where we seek to get a DNA sample from the defendant, and that's just motion practice. That also falls under 3034A. And you also have the DNA reports, and the defense attorney can waive his right to the report. He can say, I have the results, I don't need the report, let's not delay the case for the report. In this case, he very much wanted the report. So, in fact, the DNA testing time's a little bit shorter. In a lot of cases, DNA testing can be faster. Sometimes it becomes very obvious that they're not going to get a DNA profile from the samples they have.
Do you concede that you were not ready for trial without the fingernail DNA results?
I don't know necessarily, but I think I don't think for this particular period we're only arguing exclusions, and so we think the exclusions would be established, that we have sufficiently established this under the exclusions so that you don't have to reach the readiness issue. And also because the readiness law has changed a little bit from what it was when this occurred. And so that may also be, that's also sort of a factor.
Counsel, perhaps I didn't hear the answer that you gave to Judge Fahey's question. Why wouldn't the prosecution submit everything up front to the OCME?
I'm sort of limited to the record here, but of course we do. We want all this information. It only helps us. You know, if again, in our particular case, if the DNA results link to the two defendants we have under arrest, these cases are much stronger. If it doesn't, it's going to identify another perpetrator.
Slow down, but you didn't. There's no point. We're not arguing that the DNA testing here was sequential, that the semen was tested first and the fingernail samples afterwards, right? So.
That's what the ME's office decided, but that's not what the district attorney's office asked them to do, and there's a huge difference. That is a third party. They make their own decisions based on their evaluation as forensic scientists. If you ask a prosecutor, they want everything tested immediately the day before yesterday. What we can get from the medical examiner's office is slightly different, and their criteria and how they decide to test things is different.
On the record, all the DA had mentioned initially was the semen. How does the record support this position that, of course, you asked for everything up front?
Well, this goes to back our problem. This is really a 440 claim, because nobody raised this issue.
We're back to your burden, to when you say these dates are excludable or these days are excludable. It's because there's DNA testing. We asked for it, we were diligent, we did the following, but we're waiting.
Then it's up to the defense attorney to go and say, wait a second, I'm disputing that, and okay, now we're going to come forward with additional evidence. There also is true.
What? If you said, I asked for everything, this is the date I asked for it, we're waiting, what are they disputing? We're waiting?
No, whether we had established it, that we made a duly diligent request for it. And also, it can be true, since all of our requests go to the medical examiner's office, the defense bar in Brooklyn is somewhat familiar with it, so they know what some of these answers are. They can also call the medical examiner's office, so they know, they're more familiar with the procedures. Again, it's not on the record here.
Call OCME to find out the status of
And they can also
testing?
Yeah, and they can also find out who made that decision. You can look at their current manual, which is online. It's from 2015, and it says fingernail scrapings will not be done unless a supervisor has specifically signed off on that request. Now, here we're talking about 2009 and things, and we would go, and this is their policy.
I promise this is it, but that's why it's not exceptional. You know that the ME says we're not doing these, so you need an order from the judge saying, do these. And I know you're going to say it's not in the record, and that's why we got it at 440, which is a very good argument, but I just get confused that it's not exceptional.
I would suggest there are two remedies. A court could send the case out to trial, deny some adjournment, send it out, and say, you're going to try it without the DNA testing. And if you've done the DNA testing and you don't have the report defense counsel's entitled to, I'm going to bar the DNA evidence. They could do that if they wanted to. They could also issue an order to the medical examiner's office. I would suggest that would be difficult because all the judges would be issuing these orders all the time, and the poor medical examiner's office would know what they could do. But thank you.
I know I went over, so I hope I still have 3 minutes.
You may.
Okay, so can I just quickly address the non-DNA discovery argument? This is a post-readiness case. You're looking at the DA's delay alone under 3B. So even if there is other discovery, which I believe I agree with Judge Stein, that the record does not support that there is a specific request for additional discovery. And I'd also note that the date for completion of open file discovery had passed. That was March 2009, so that had passed already. So even if the DA is handing over other discovery, that's not reasonable or not a basis for the exclusion, and defense counsel would have known that that date, the March 09 date, is in his initial 3030 motion.
You concede preservation's an issue, right?
I'm raising this as an effectiveness. I absolutely concede that the argument here isn't preserved.
Honestly, as Ms. Bordley points out, you make the motion saying speedy trial, and then they say, here are the answers, and you've got to preserve a complaint about a specific time.
Yes.
Which surprises me, because it would, go ahead.
This court's case law is very clear about counsel needing, if the people identify a basis for the exclusion, defense counsel has to reply and say what factual legal impediments prevent or bar the exclusion from applying. That all counsel had to do here was to say they didn't even say due diligence. They just said DNA, or they pointed to discovery, which doesn't apply.
So you agree with the people, it's not their burden up front?
No, it's their burden in their response papers, or it's their burden, I mean, it's their burden throughout the process and certainly at the end in their response papers. Again, look at the fact that you've got the judge and you have defense counsel asking the people about the status of the DNA testing for at least 3 adjournments. By the time it gets to their response, they've had 4 bites at this apple, and they didn't say a word.
So I'm sorry. So is your argument then that counsel is ineffective for failing to point out they had not met their burden, or for failing to meet his own burden?
For replying and pointing out, supplying the court with a legal reason, a legal basis to dismiss.
Can you do that orally?
Could I do that orally?
Yeah.
Yes.
So why do we know that it's not preserved? I could see these papers going in front of a judge and there being oral argument, not on the record, in which the defense lawyers say, Judge, look at this. This isn't exceptional. The ME is late as usual. That's not exceptional at all. I win.
Well, we don't even have that argument said
Right.
anywhere.
Which is what Ms. Bordley's saying, why we ought to have a hearing.
But that's why counsel's ineffective.
Right, but if, going back to the earlier point that you were just discussing in our clear procedure for preserving, wouldn't it be at that point that this issue would have been explored on the record? And we don't have that record. So we're trying to reconstruct what their arguments would be, what counsel's arguments would be there, and isn't that really a 440 motion?
Not when you've got not when you have the people agreeing that there is agreeing to a final conference once they have the semen results, because having been asked, because at that point, in their mind, all necessary testing is final, it's complete. It's only after that that there's a discussion of additional tests. In light of that, no, we don't need any further information. They didn't make, and the fact that they didn't come back, when the court asks, we've been waiting, prosecutor, we've been waiting since May for these results, and this is in August. And the prosecutor simply says, additional testing. That's it. Doesn't explain that they asked for, when they asked for it, or didn't demonstrate their due diligence.
Right, but I know we're over, but you're pointing to things that are in the record, and they're there, but they're not in the format of this argument and a response. So we're reconstructing from different parts of a transcript what might be the answers to a motion had it been made,
Had counsel...
properly made.
Sorry. Had counsel simply said, and I know I've said this 100 times, I'm very sorry. If counsel had said the people haven't met their burden and the court denied the motion and this went up on appeal, it would have been reversed. It should have been reversed. Under this court's case law, under McKenna, under Anderson, under all of these cases where the people have to establish that they acted reasonably, this would have resulted in a dismissal.
But those are cases where we had a record to make those determinations.
But even under Washington, for example, where you have the people simply saying investigation and not demonstrating their credible and vigorous efforts, that's where you find fault. You find fault with the prosecutor not demonstrating those things affirmatively.
Thank you, counsel.
Thank you.
Next, appeal number 128, People v. Nnamdi Clarke. Counsel?
Good afternoon. Sharon Broad from the Office of Richard A. Brown for the People. I'd like to reserve 2 minutes for rebuttal, if I may.
2 minutes?
2 minutes, please. Okay. In this case, there were exceptional circumstances demonstrated by the people because this is an unusual case. And I start with the fact that exceptional circumstance is a fact-specific issue for each and every case. This is a DNA case where subsequently the Second Department has determined if the people do not diligently request the defendant's DNA to match against the sample that they have from
Counsel,
the crime
just
scene.
to go to that point right away, I mean, isn't this the flip side of the case we were just hearing? I mean, this is a fact-specific question. We're not going to, I mean, are the parties asking us to put a rule in that DNA testing never counts against the people's time, or it always counts against the people's time? I mean, it's really a case-by-case, fact-specific inquiry. So what would we do here with it?
Precisely, Your Honor. And what we're asking the court to do is 2 things. One of them is to determine that due diligence is determined by the facts of the case. And in this case, the appellate division simply erred in finding that under the very unique facts that don't even exist anymore, unfortunately, it doesn't have a specific impact going forward because the circumstances that existed here, and I'll get to them in a minute, don't exist anymore. But in general, that due diligence is very fact-specific, and that due diligence can be demonstrated in different ways, and it's not determined, as the defense would have it, by what the people could have done, but what they should have done
So
under the
how was
circumstances.
due diligence demonstrated here?
Okay, so what happens here is there's a cop shoot, so there are crime scene swabs all over the place, and what they are is off guns, all right? And at the time, and this is what makes it unique and not the case anymore, it was very rare to get samples, DNA samples off of guns. The reason they existed in this case was for two reasons. For one reason, which is that it was low copy DNA. It was a very small sample off skin cells, not typical at the time, not semen, not serological, not blood, not any of the things that one would expect to yield DNA. So two things happened. First, there was an unusual type of DNA being collected, or being derived by the OCME, and second, that the OCME had a protocol which also doesn't exist anymore, of not notifying the people unless there was a match. Because this defendant happened not to be in the system, there was no match. And this case, because of that, is extremely unique, and we are saying that we're not saying that if there were a rape kit that had been tested, as in the other case, the people wouldn't have had a burden if they didn't get a result after a certain amount of time to
Counsel,
say.
let me understand what you are saying. You're saying that because this was something that was new at the time, that the people didn't have some sort of burden to follow up with the OCME to get any kind of result from, or whatever the OCME was going to say about the swabs that were taken?
That's exactly what I'm saying. What I'm saying is that, for example, if it were a rape kit or if there were blood collected, the prosecutor would have been on notice that if somehow OCME didn't contact us after a certain amount of time, something was wrong. We needed to call.
Why then, when he was arraigned, did you say you were ready for trial?
At the time, we had two guns. The case also changed posture in the middle of the case when the first gun was suppressed, and that changed the nature of our case.
But
We
you're
were going to try it
either ready for
without.
trial or you're not. And you know, part of this that I didn't ask on the first case, don't the police do this stuff? I mean, why isn't the police taking stuff to the medical examiner and asking it be tested and then bring it to you? I mean, there's statutes of limitations that aren't even close. And then it is ready, and then it goes to you, the lawyers, and then you can move it ahead. For you to assume the burden of further investigation, and then attribute that, and then delay the whole case. I mean, I keep looking at these things. This is an almost 10-year-old case that's in front of us now, but that's another issue, I guess. But the delays are incredible.
Okay, Your Honor, there are a number of things here, and at a risk of going off my topic, first of all, the police did do the testing and did deliver it to
So you were ready
OCME.
at arraignment. When it was indicted, you could have picked a jury that day, and this case would have been over.
Precisely. Had the first gun not been suppressed, we were never intending to look at DNA. So that was one thing that also changed, and the court noted that in its
But
decision.
even after it was suppressed, did you need the new type of DNA? Did you need that in order to proceed?
We didn't absolutely need it. We could have proceeded without it. But 3030 law, and let me address the question that was asked before. First of all, at the risk of diverting from this argument, 3030 is not a statute meant to get a defendant to trial. I'm going to sacrilege here.
It's
meant
not
to
a
get a
statute, I'm
defendant to
sorry?
trial within 6 months. That's not actually what 3030 is. Constitutional speedy trial is what looks out for a defendant not sitting forever in jail unfairly. The people can lose a case.
Well, it's to prevent prosecutorial dilatory conduct. So
Precisely.
why are you not dilatory here when you don't even ask?
Okay, if I may say, as the court knows, we can lose a case off one day. We can be ready within 183 days, where there's 182 days in the 6-month stretch, and we can lose a case. So it's clearly not about the absolute speed about which defendant goes to trial, but it is about us being ready, us being not dilatory. And again, readiness has a certain definition. It's somewhat up in flux right now because of Sibley's and because of the cases that are currently on appeal from the Sibley's issue, but it has never meant, trial readiness has never meant that the people have to forego collecting additional evidence during the pendency of the case.
Counsel,
It means
can you tell me, when did the people, I think in your papers you say that the OCME faxed in May something about results from the, that they had a new test that they could do, the LCN test. Now, when did your office, or when did the people ask the OCME about the results that had been, or the sample that had already been provided?
Okay, and that's one of the key questions, because, and I'm low on time, but one of the key questions is that because the defendant's DNA had yielded some sort of result well before, and OCME had that result, it is not 100% clear from the record, but it is at least inferable from this record that the reason OCME faxed us that letter in May was based on our request. That was when we...
Well, the problem is I thought in February 2008, OCME issued a report that was 5 months before OCME's report became final in 2008, and now the prosecutor knew about this, and he reached out to OCME 5 months after that, in May of 2009.
No.
Shaking your finger.
No, I'm saying OCME had a report, but they did not notify us of that.
So,
the date on that
so let me
report...
stop this. Stop. What, if you asked that question 9 months later, why didn't you ask the question a year before? What took you so long?
That's it's not quite a year, but that's the key question. Why did we ask in May?
Well, so tell me the answer.
Right. And the answer is, we don't know 100% from this record. And here's why we're recommending...
Is the argument that we're having right now, is that a preserved argument?
It's not preserved by the defense, but we didn't rely on preservation for the following reason. The record is a little bit murky, as 30-30 records
The
tend to
reason
be.
I ask about preservation is the only thing I see is preserved is that that the people's argument that they shouldn't be expected, that they should be expected to request a DNA sample during plea negotiations. That's the only thing that actually seems to be clearly preserved for appellate review. Seems like everything else is unpreserved.
No, there's more to that. There's more, one of the things the prosecutor argued, but there's oral argument that preserves additional information at various adjourned dates. There's argument about the fact that defense attorney was not conceding that he would go forward with this low copy DNA, for example. I see my time has expired, if I may just finish. DNA, he was not conceding that, and therefore we would either have to do a Frye hearing or wait for the results of the other Frye hearing. There are other arguments preserved. But if I may quickly go to the core thing, one of the remedies we're asking for here is a hearing that perhaps should have been ordered by the 30-30 judge below. It's not unusual for the appellate division to remand for a hearing where they say due diligence should have been further explored. They did that recently in another case in Queens about producing a defendant. What was our due diligence? So all I'm getting to here is one of the reasons we're asking for a hearing as a remedy is precisely that. It's unclear why we asked. I have additional knowledge that I can't, it's not part of the record, but we can speculate about some reasons, including the fact that now LCN DNA was becoming more common. They were recovering stuff from guns.
The problem with that argument, listen, is that scientific advances in DNA testing have been going on all the time. You have to deal with it. That's the bottom line.
Right.
That's your obligation. You can't tell someone they got to sit in jail for 6 more months while you develop the protocol to address scientific evidence that's your responsibility to bring forward. It's an impossible situation to try someone under.
Correct, Your Honor. And that's why we're saying it's the combination of two things. The fact that it was new and therefore the prosecutor would not have known to request it, and the fact that there was this protocol.
So the reason he didn't request it, I guess it was 9 months earlier when he really could have practically, is because it was new, in essence.
We don't know 100%, but that may be one of the reasons. There are other reasons as well.
Related question to that, is the question of due diligence a mixed question of law and fact?
I believe it might be. And the issue here is, should the appellate division perhaps have remanded for a hearing? Certainly this court, and unfortunately, it's not one where there's a sufficient record to uphold the appellate division's decision, even if it's a mixed question of law and fact, because in this particular case, there are issues that need to be resolved.
Yeah, and law and fact, see, that's another one. I thought that was just raised in the reply brief. It wasn't raised earlier, I didn't.
What, I'm sorry?
Your contention that it may be a mixed question of law and fact, you cite Luperon, I think, and that was only raised on reply.
It may well be, Your Honor. I don't recall, but we weren't so much relying on it. We were more relying on the idea that perhaps this is the remedy here is a hearing. So, and that we did raise in the main brief.
Thank you, counsel. Counsel. Counsel, what about your adversary's argument that the prosecution is a dynamic, ongoing event and that the need or the perceived need to test evidence develops through the process?
Well, in a vacuum, maybe that's correct, but there has to be an endpoint. Otherwise, what is the point of 30-30? You can't have the people wait until the eve of trial in May 2009 and say, hey, you know what, there was a gun tested, let me find out what those results were. This incident occurred in November 2007. Within 3 months, the OCME had a report saying from the swab, the DNA was found on the gun. That is in February of 2008. 15 months go by, 15 months before the people finally reach out to the OCME and they say, what's going on with the gun swabs? And we know that because the people acknowledge it in their brief on page 6. They say that it was apparently pursuant to the prosecutor's query. And when we look at the facts from the OCME sent to the people, which is on appendix page 133, it says, as per request. That's dated May 13th, 2009. So on the eve of trial, the people decide, let's start the DNA process now. And that is why they'd failed to show due diligence.
Do we know whether that LCN DNA test was available before May 2009?
It's unclear from the record, but I don't think it matters. The due diligence doesn't shift based upon technological advances. They knew that the swabs had been sent to the OCME. And the people raised...
What if counsel, in March, April 2008, after the OCME's report came out in February, the prosecutor called the OCME's office and they provided these results, but then later on, it became clear that there was a new test that could have been conducted to find out about the DNA results. Would that change anything?
It would change something. Well, that would be a year in advance from when they actually did. So yes, that would show more due diligence than they did here. But waiting more than a year after that
So it's
initial
only
report,
if they only need to request something, whether that request results in anything or not. They just have to show that they made some effort to find out what the DNA result was.
as this court said in Washington, they have to show vigorous activity. This is hardly vigorous activity. This is no activity. The people put forward all these different grounds for why there were delays. For example, they say the suppression ruling. The suppression ruling changed everything. It changed the entire case. The suppression ruling suppressed the gun that was discarded first. The suppression ruling had no effect on the crux of the case. The majority of the counts in the indictment concerned the unsuppressed gun. So if the people knew that was the focus of the case, there's no reason why the suppression ruling should have delayed requesting the DNA swabs. In addition...
I'm sorry, but I'm still kind of back at what are we really being asked to review here? Because it really does seem, the appellate division found this was not excusable or exceptional circumstances, based on a whole variety of facts, which you were just getting into some of them. So I'm puzzled somewhat by what are we supposed to do with that ruling? I mean, as a matter of law. I mean, they looked at this, we've talked about mixed question, and I don't understand what are we supposed to review. Are we supposed to make a rule that says it's never excludable, it's always excludable, or is this really something that we don't reach?
No, Your Honor, I think that the court
By the way,
should...
that's a softball question.
I welcome any. So I think this court should issue a rule saying that in a DNA case, it is the prosecutor's responsibility to show due diligence in vigorously pursuing the DNA evidence.
That's the law now, isn't it?
It is the law now.
So why do we have to say it again?
Right.
Well, I think some prosecutors' offices need
Because I think
reiteration.
Ms. Broad's right to some extent. You know, it's funny when you read these cases and it says, when they address speedy trial, they say, well, it's 6 months, and they say, in this case, 182 days. In this case, 183, because it's a loose, she's right, it's not, you know, it's not some constitutional thing. It's 6 months, and the 6 months ebbs and flows depending on which 6 months are in there. So
Correct.
it gives you the impression that, on the whole, get the darn thing done, but there is some play.
Well, sure. In speedy trial itself has certain exemptions that are pretty broad, motion practice, discovery, things like that. But here, because the people waited for months and months before they even inquired, it's clearly not due diligence.
So if we have the rule, Judge Biggett was just saying, and the appellate division applied it to these facts, what more is there for us?
An affirmance, Your Honor. That's what I would ask for. Because
the ultimate
yes, it's well established that based upon the case law, the people fail to show due diligence.
So is there due diligence if they inquire, let's even be generous, they inquire weekly, and it's 3 years later and they still don't have results?
Yes, that would show due diligence. That's showing some effort. That's showing vigorous activity.
They're not responsible for any delay on the OCME side under the statute, because the statute is focused on them and their conduct.
That's correct. That's what the statute's about. 3030 is intended to be a statute where it encourages the people to show diligent prosecution, eliminate...
Well, you'd be making the argument that you can't just ask, and after you don't get an answer after 3 requests, you ought to bring a motion. You would say it's not due diligence to send 12 consecutive
Well,
monthly
yes,
letters.
if it went on for 3 years and all they're doing is making a phone call and nothing's happening, yes, I don't think that reaches the level of due diligence. It changes.
That was the question.
That wasn't the question.
No, that
but
was the question.
Well, it was, if they are, my point was if they are continuously active, continuously in contact with the OCME, and continuously trying to move the prosecution
But
along.
yes, as Judge Pig is already pointing out, does there come a point when mere inquiry, and I think as Judge Abdus-Salam was suggesting before, is not going to be enough if indeed the OCME is taking time that from the defendant's perspective
Yes,
is too long?
yes, absolutely. I didn't mean to be too...
We need to address that here?
Well, in this case, we didn't even reach that level. So I don't know if
No
this is a
inquiry.
proper case to address it. I think this case should declare again the rule that when the people fail to show any effort, it clearly does not meet due diligence. I want to touch quickly on the fact that the people's argument that they say this wasn't traditional DNA. It's irrelevant. It's clearly irrelevant. We can't have a sliding scale of what constitutes due diligence based on scientific advances. The people knew the gun was tested for swabs. That alone, it doesn't matter what evidence.
But I thought due diligence was and maybe you don't agree with this, is a sui generis inquiry. It depends on the circumstances. So why couldn't the suddenly new availability of some scientific process constitute extraordinary circumstances?
Because in this case, they made no
I'm
effort.
talking about this case.
Okay.
I'm talking about, I thought I heard you say that it can't be a sliding scale. So my question was, why not? Why can't that be considered in appropriate circumstances to be exceptional?
My reference to sliding scale was more in the sense of because there's a new technology, we drop the ball altogether. That's not permissible.
Well, let's just assume that they were inquiring and prodding to get this DNA, and then they find out that suddenly they find out that there's this new process, and so they want it.
But the OCME had done that in February. They had discovered this, but the people just, the fact that the people are claiming that because there was this new technology, they don't have to inquire at all, and that can't be the rule.
No, but that's not my point. My
Okay.
point is, what if they were inquiring and then came to find out that there was this new process?
That would be fine. If they were inquiring, they were showing due diligence, but here they were not. Unless the court has any further questions, I ask for an affirmance.
Thank you, counsel.
Thank you.
Ms. Brett?
Here's why this is actually not as simple as affirming where there's some factual dispute and the appellate division seems to have resolved it against us. This is the unique situation where we didn't just not inquire. We didn't inquire because we relied upon a protocol of the OCME that we believed was in place. It was a protocol they set up. We relied on it in part because the technology was new, so we had no reason to believe that we should be inquiring. And that's my point about due diligence, that due diligence, because it's fact-specific, because it depends on the circumstances of the case, normally, again, my example of if it were a rape kit or blood, and we knew it was tested, we didn't hear from OCME, and we sat on it for a year and 3 months, that would be a very different circumstance from thousands of guns that are being swabbed, and nothing.
So the
we don't-
prosecutor has no obligation to keep current with the new technology and what's being done in the forensic science labs?
Of course, the prosecutor has an obligation, but here's the thing. The thing is, at that point, it was so new that it almost didn't exist in terms of what OCME was reporting to us. What happened was, it did become probably one of the things that, again, it's speculation because the record is not clear on this, one of the things that may have kicked off the inquiry was the fact that now it was becoming known that there was some results coming off of guns, and we saw that we did have the voucher. We always had the police voucher that showed that it had been swabbed, and we looked at it and we said, wait a second, maybe there are results. It's not clear what prompted the prosecutor, but for some reason she called and she got the results. It's, again, the point I'm trying to make is that it's very fact-specific, and on this record, the fact-finding by the appellate division was incorrect. And that's why we're asking this court, at the very least, to remand it for a hearing.
There's really very little facts in the appellate division opinion, but what they do by their decision is say they looked at all these things. They looked at it as a new science, and as Judge Stein was getting at, there may be circumstances, but they decided these weren't those circumstances where this was excusable. So really what we would be doing is just looking at those facts and saying, no, under these facts, that it is excusable.
Well, this court does have that level of factual review power of looking at the facts and saying that the results, that the conclusion of the appellate division that this time, that we did not show due diligence is not supported by the unique circumstances of this case. And therefore, it would be just unfair to ask the prosecution to have a due diligence requirement under, we always have a due diligence, to have met that by what the appellate division was requiring of us.
Thank you, counsel.
Thank you.
Thank you all.